You've sued a doctor in a medical malpractice case here in New York, and now I'm ready to put the doctor on the witness stand. The mere fact that I call this witness to the stand, does that mean that I am vouching for his credibility? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Typically, when I put a witness on the stand, I am inherently telling the jury that I am vouching for this witness's credibility. That means that I can typically only ask open-ended questions, known as a direct examination. I can't ask leading questions. And typically, when I put a witness on the stand to support our claim in our case, I'm doing it because I'm basically telling the jury, listen, this witness will give testimony that's favorable to our side, and I'm vouching for this witness's credibility. On the other hand, there are many times in a medical malpractice case where I will have to call the doctor who you are suing, known as the defendant, onto the witness stand. Now, something interesting happens here. What happens is that because he is now unfavorable, he is now antagonistic to our claims, he has a different position and a different agenda. Now something unusual happens. I am no longer vouching for his credibility. Instead, what is happening is that I am required to call this particular witness, this doctor, to the witness stand because I need him to establish a number of things in our case. I need him to establish what the standard of care is. I need him to go through and explain to the jury what he did and why for the injured victim. And now I have the opportunity that even though I have called this witness to the stand, I no longer have to ask him just open-ended questions. Doctor, tell us what you did. Instead, I am permitted in New York to ask leading questions. And this allows me, number one, to control the witness, and number two, to get information that I specifically want to get in front of the jury. Now, obviously, when I'm done questioning this particular doctor, his attorney, the defense lawyer, will have an opportunity to conduct what's known as a direct examination, asking the doctor open-ended questions. And that'll give the doctor an opportunity to go ahead and explain. But when I call the doctor to the witness stand, I am not vouching for his credibility. Instead, I am showing to the jury that this witness is antagonistic. This witness is sort of a hostile witness to our claims. And now I am permitted to ask the witness cross-examining type questions that require either yes, no, or I don't know, or I don't remember. And this way, the jury will then have an opportunity to truly judge whether or not this witness's testimony is credible. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the trial process here in the state of New York in a medical malpractice case. You know, I recognize that chances are you have questions or concerns of your own about your own particular matter. Well, what I encourage you to do if you have legal questions is to pick up the phone and call me. I can answer your legal questions. I do this every single day and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski here in New York. Have a wonderful day.